Hello, my name is Michael Massman. I'm an attorney with Neighborhood Legal Services of Los Angeles County. And this presentation is about whether or not bankruptcy can save a home. And that means either a rental home or a house or a condo that's in the process of being paid off. This presentation is meant as information only. It is not legal advice. If you need legal advice, you should consult an attorney on the specifics of your own individual case. So we're going to talk about two types of bankruptcy. I'm going to talk about a Chapter 7 and a Chapter 13. I suggest, because understanding how this plays out, it's helpful to understand a little bit more about bankruptcy. I strongly encourage you to review the other videos and material on our website to get a better handle of that. Additionally, you can reach out to us for one of our Chapter 7 workshops that we conduct every Friday remotely. So we'll talk a little bit more about the specifics of Chapter 7 as opposed to a Chapter 13. We're going to talk about both of them. Broadly speaking, a Chapter 7 is a liquidation. You protect some property with laws, other property can be taken. Chapter 13, on the other hand, is what's called a reorganization, and that's where you come up with a plan to pay off your debt over time. So first, we're going to focus on Chapter 7. And this is just sort of immediate questions or immediate answers to questions. So can a Chapter 7 bankruptcy prevent an eviction? The answer is no. It can briefly delay an eviction, and we'll talk about how that plays out in a little bit. Can it discharge rental debt? Yes, it can discharge rental debt, but only the rental debt that you owe as of the date of filing. Rental debt that becomes due after you file is not debt that can be discharged. Can it prevent foreclosure? The answer is no. It's much like eviction. It can delay it very, very briefly. So let's look a little bit closer at these. Bankruptcy and eviction. Why can't Chapter 7 stop an eviction? Well, when you file bankruptcy, what happens is an automatic stay goes into effect. That automatic stay prevents your creditors, including your landlord, from taking any actions to collect or enforce a debt without permission of the bankruptcy court. And it's this automatic stay that provides the brief delay. So how does this work out? A tenant files bankruptcy, then the automatic stay goes into effect, and the landlord is notified of that because the landlord needs to be listed on the bankruptcy filing. If the landlord wants to proceed in state court, the landlord can file what's called a motion for relief from the stay. If rental debt's owed, the bankruptcy court grants these routinely. So it can only sort of put a brief road bump in the way. If rental debt is owed or the lease has been breached, then a motion for relief from the stay will almost invariably be granted, and one will be back in state court dealing with the eviction proceedings relatively quickly. How about back rent? As I said, so back rent can be discharged. So back rent is rent that you owe as of the date that you have filed. Perhaps you've accumulated a number of months. That debt can be discharged, but it will not prevent the eviction. And importantly, if you're still in the apartment, you can owe debt going forward after the date that you filed your bankruptcy. So how about foreclosure? Well, the process is very, very similar. It cannot directly help you to save your home. It can perhaps delay the process. It's similar to eviction. Again, you file the bankruptcy. The automatic stay goes into effect, and that prevents creditors from taking actions to collect on their debt without permission of the court. But the lender, like the landlord, can ask the court for relief from the automatic stay. And if you owe money on your mortgage, then the bankruptcy court's going to routinely grant that. The bankruptcy courts handle debt. They don't necessarily handle a right to property in the way it's handled in eviction or foreclosure proceedings. So to sum up, you can delay these processes, but a Chapter 7 can't save your home. There are, however, some protections for a home. So if you're filing with a Chapter 7, there's a homestead exemption, and if you've lived in your home for a certain period of time, it's your primary residence, you can exempt up to about $720,000 in equity in your home as of the recording of this video, which is 2025 in December. So if you have equity above and beyond that amount, the trustee can take the home, sell it. You can still protect your homestead exemption to the extent that the approximately $720,000 should come back to you, but you are required to reinvest that within 6 months in another home. So there's protection for your home, but if you're behind, it protects your equity in your home. But if you're looking for protection because you're behind on payments, Chapter 7 is not going to help with that. It's going to at best put a road bump in the way, or a speed bump in the way of the lender. Let's talk a little bit about Chapter 13. Now, we run a self-help center. We help people with Chapter 7s. We do not help people with Chapter 13s, or only to a very limited extent. I will say that before I do this, we can help with referrals to Chapter 13. So what is a 13 as opposed to a Chapter 7? As opposed to just filing bankruptcy and using laws to protect your property, you here come up with a plan, either a 3-year plan or a 5-year plan to catch up on your debts. And these Chapter 13s are very challenging. We strongly encourage people to work with an attorney. Over 90% of them without an attorney fail, and many of them with an attorney do fail. They're complex and they take a lot of dedication because you have to make payments over 3 to 5 years. But if you have income coming in such that you're able to catch up on payments you're behind, a Chapter 13 may be a great option for you. And we can certainly help with a referral to private attorneys that would work with people. So if that's something you're interested in, you're encouraged to reach out to us for more information on our website. Something to be aware of. Bad faith filings can be a risk. And so what's a bad faith filing? A bad faith filing is somebody who files bankruptcy for a reason other than a legitimate discharge of debts. Bankruptcy is here to do 2 main things: discharge the debts of the debtor and equitably, that is fairly, distribute any proceeds or any payments to the creditors in the bankruptcy process. So if you're simply filing to avoid an eviction or to avoid a house, there's an argument that that's a bad faith filing, and there can be problems with a bad faith filing. So some of the consequences of a bad faith filing: you can get a dismissal without ever getting the discharge. Repeated filings can result in bans on filing again and the permanent loss of a right to discharge the debts. You can even lose non-exempt assets, and there can be sanctions for debtors and attorneys. So again, the primary purpose of the bankruptcy code is to discharge, relieve honest but unfortunate debtors of their debts, and to fairly distribute any proceeds from the bankruptcy estate to creditors. Filings for other reasons than that can be considered bad faith filings. Consequences just generally of filing bankruptcy. So before you do this, even if you're just, doing it on a wing and a prayer, so to speak, you should understand that bankruptcy will be on your credit report for 10 years. If you're doing it to deal with rental debt, having a bankruptcy on your record can make it harder to rent a new apartment going forward. And certain jobs, they can consider this. It could affect your credit reports and stuff. And not every job, but certain jobs, that could be an issue. So where to get legal help? You can call our general hotline. If you're having housing issues, you can reach out to Stay Housed LA. You see the website here. If you want help with a Chapter 13 bankruptcy, here are some referrals from the San Fernando Valley Bar, for example, and the Los Angeles County Bar. You're also welcome to reach out to us if you'd like additional referrals. Further, on the Bankruptcy Court's website, there is currently a list of Chapter 13 attorneys that you can reach out to through the Central District of California Bankruptcy Attorney Association. So I hope this information has been helpful. Thank you very much for your time.